So welcome back. We would like to discuss a very unique scholar. Unique in the sense that it is difficult to classify him as belonging to the natural law school or classify him as belonging to school of legal positivism. So what we'll do is that we'll discuss him and the contributions that he made to legal theory. And you'll be invited either exam time or at some point for you to make a case as whether this scholar can fit the label legal positivism or natural law or something of a hybrid. I present to you Ronald Dworkin. So we want to explore his contribution to legal theory. Ronald Dworkin, a fine scholar. He was professor in Yale, New York, Oxford. And if you look at his work, commentators will agree that Ronald Dworkin is known for rejecting both natural law and legal positivism. And he will rather emphasize what we call the law's interpretive nature. I mean, despite his seeming rejection of natural law and legal positivism, I still want us to leave the question open as whether he could still be classified as being a natural lawyer or being a legal positivist. He's done a number of works, but his main works of interest in trying to get a sense of his contribution to legal theory, taking right seriously, the law's empire, and also how to call the right answer thesis. Now, the law's empire is what I would like the class to read. And our next set of presentations, there will be students will be required to review aspects of his discussion of the law's empire. This is something that we do almost every year, and it's very useful exercise. So hold yourself in readiness for that. Dworkin rejected natural law because he found natural law to be steeped in what we call a priori reasoning. And Dworkin would rather say that the a priori reasoning is just an exercise in abstraction, metaphysical speculation. Rather, the proper focus should be an empirical analysis of legal system. So practically, as the legal system is in operation, how do we see it? What do we find? So that is more important to Ronald Dworkin than what natural law school will help us to follow. That is their a priori reasoning. Now, Dworkin also has something against legal positivism, He challenged the approach of legal positivism in reducing law to mere rules. And of course, when he launches this kind of attack, as one of the reggae musicians said, he who the calf fit, let him wear it. Is it is it Bob Marley? Or yeah, one of the reggae musicians. So when Dworkin is attacking legal positivism for reducing law to mere rules, he is implicitly targeting H.L.A. Hart, Professor Hart's concept of law. As you remember from our previous class, Hart's concept of law would actually talk about the fact that, okay, so Elizabeth, you enjoy reggae, okay. God bless you. So it says Bob Marley. So Hart will have told us, as we saw previous class, that he saw law as a system of rules. And Dworkin is actually having a problem with that, that it is not enough for you to look at law as a system of rules, but it is important for us to pay attention to moral and ethical standards as well. So not just the rules, but the moral and ethical standards. So when I speak like this, then you say that, but is Ronald Dworkin not then falling in love with natural law proponents? But wait a minute and let's move further. So Dworkin would like law to be approached as an interpretive practice. And that is why he said that he is interested in we looking at an empirical analysis of the legal system. So law is not just a system of rules, but it includes principles. And I want you to understand and underline that. It includes principles that reflects the community sense of justice and fairness. So principles that reflect community sense of justice and fairness. So that is what law should be understood as consisting in. He sees the standards as very important here, that just having rules is not enough. There are policies and principles which seeks to achieve social goals and moral requirements in the society. And those should be factored into any calibration as far as law is concerned. So it's not just enough to say that these are the rules. So ostensibly referring to like HATs, the primary rules, the secondary rules and all that. But it's also saying that there's a policy dimension. There's certain principles, certain ethos in society. So what does Dworkin mean law as interpretive practice beyond mere rules? Dworkin advanced the view that law constitutes an integrated system of rules, principles, and policies. An integrated system of rules, principles, and policies. So mind you, he's not saying that rules are not really important. They are. But what he's rejecting is equating law to just rules. Just as scholars like Hart will have had us to believe. So Unlike legal positivism view, which strictly delineates law as a system of enforceable rules determined by a sovereign authority, Dworkin's interpretive approach sees law as imbued with moral and ethical consideration that mirrors the community's values. So the community has got certain values. So like Ghana, for example, if you are using Dworkinian reasoning or Dworkin's thinking, that our society, our legal system, there are certain values we hold here, and Dworkin who have told us that as we go through legal training, legal education, and all that, directly and indirectly, those values who have been imbibed or inculcated in us, and they are deeply embedded in our subconscious. And for that matter, anytime you are playing the role of an adjudicator, maybe like as a judge, and any situation is brought before you, even if there is no direct precedent speaking to it, you should be able to fall on the reservoir of the community sense of values, which you have actually imbibed already, to be able to come out with appropriate solutions, which will let your decision fit rightly within the legal system and make it coherent. So in a nutshell, that is what Dworkin will be telling us. So apart from this integrated system, he also identifies the interpretive nature of law. Interpretive nature of law. And by this, Dworkin is saying that legal practitioners, judges, especially, and those who play rules in adjudication, engage in an interpretive process when applying the law. So the application of the law is an exercise in what? Interpretation. And this process is not about mechanically applying rules, but about understanding and applying the law in a manner that best aligns with the community's moral and ethical values. So that was the point I was trying to emphasize. Yes, application of the law is not just, oh, what does the law say? Okay, this is no, but it's not just mechanical. It is, more importantly, you making effort to ensure that the law you are applying is in agreement with the community's moral and ethical values, which have been instilled into you through your years of education and training. What is the role of principles and policies in the interpretive practice of the law? For mind you, Dworkin has told us that law is not just about rules, isn't it? But we also need principles. So where principles are not applied in an all or nothing fashion, but serve as moral guidelines that influence legal reasoning. In other words, the principles are not something rigid, that it is either read. If it's not read, then it is out of it. No. And that is what they mean by saying that the principles are not applied in an all or nothing fashion. But more importantly, it serves as a moral guidelines when you are doing legal reasoning. So principles demand a level of interpretation and judgment from the court that goes beyond the binary application of rules. So binary application of rules here, binary means like either or. Does it satisfy this box or not? No. It's much more than that. They reflect That is, the principles reflect deeper societal values, such as fairness, justice, and equality, and require a balancing act in their application to specific cases, So those are the things. And of course, don't forget that I always love going back to the content of our oaths, which we take. For example, if we take like the judicial oath, okay, go to the second schedule of the Constitution, and somebody should read the judicial oath for us. Who will read it? The second schedule of the Constitution, the judicial oath, who will read it? Are you sleeping or you are here? Okay, James, cool. James, because Elizabeth mentioned Bob Marley, let her read this. Elizabeth?
Yes, my lord.
Yes.
Okay, so the judicial oath says, I, having been appointed Chief Justice, a Justice of the Supreme Court, a Justice of the Court of Appeal, a Justice of the High Court of Justice, etc., do in the name of the Almighty God swear, solemnly affirm that I will bear true faith and allegiance to the Republic of Ghana as by law established, that I will uphold the sovereignty and integrity of the Republic of Ghana, and that I will truly and faithfully perform the functions of my office without fear or favor, affection or ill will, and that I will at all times uphold, preserve, protect, and defend the Constitution and laws of the Republic of Ghana. So help me God.
Good. And please read the preamble to the Constitution for us. Just the preamble. The preamble of the Constitution is the opening part of the Constitution. Okay. The preamble of the Constitution. Before you go to the chapter 1, the document, the preamble.
Yes. Yes. It says, we the people of Ghana, in exercise of our natural and inalienable right to establish a framework of government.
You left something. You left one line, which is important. So go back.
In the name of the Almighty God, we the people of Ghana, in exercise of our natural and inalienable right to establish a framework of government, which shall secure for ourselves and posterity the blessings of liberty, equality of opportunity, and prosperity, in a spirit of friendship and peace with all peoples of the world, and in solemn declaration and affirmation of our commitment to freedom, justice, probity, and accountability. The principle that all powers of government spring from the sovereign will of the people. The principle of universal adult suffrage, the rule of law, the protection and preservation of fundamental human rights and freedoms, unity and stability for our nation. Do hereby adopt, enact, and give to ourselves this Constitution.
Good. So you notice that if you take the content of the judicial oath, which Elizabeth read for us, judges have signed up to certain responsibilities, certain values, which our society has actually agreed that should be upheld by those who play the adjudicating role. And those are the things that we heard. And it also includes the fact that they will uphold the Constitution and the laws of Ghana. And you read the preamble to the Constitution, you notice that certain values, certain things have been stated there. And all those things are supposed to be part of what in Dworkin's language we call, like, if you like, the principles, which is said reflect deeper societal values such as fairness, justice, equality, sugana, probity, accountability, and all that. So when adjudication is being done, they're supposed to be considered. Policies. What does Dworkin means? So while principles address moral and ethical standards, policies in Dworkin's framework are about societal goals and objectives. So policies direct the law towards a certain end, such as reducing crime, improving public health, or enhancing social welfare. And they are designed to reach a desired outcome and influence interpretation and application of law towards achieving broader social improvement. So I would like somebody to read or read chapter 6, the directive principle of state policy, just the beginning. That's the opening, just the article 36. Article 34, yes, James, Article 34. Article 34.
Okay. Chapter 6, the directive principles of state policy, Article 34, Clause 1. The directive principles of state policy contained in this chapter shall guide all citizens, Parliament, the President, the Judiciary, the Council of State, the Cabinet, political parties and other bodies, and persons in applying or interpreting this Constitution or any other law, and in taking and implementing any policy decisions for the establishment of a just and free society.
Yes, so please read Article 35. Yes, that's Article 35, Clause 1, Clause, and then we jump Clause, and then we jump to Clause 3. Yes.
Article 35, political objectives, Clause 1. Ghana shall be a democratic state dedicated to the realization of freedom and justice, and accordingly, sovereignty resides in the people of Ghana, from whom government derives all its powers and authority through this Constitution. Clause 3. The state shall promote just and reasonable access by all citizens to public facilities and services in accordance with law.
Okay, good. Now, please jump to Clause 6.
Clause 6. Towards the achievement of the objectives stated in Clause 5 of this article, the state shall take appropriate measures to A, foster a spirit of loyalty to Ghana that overrides sectional, ethnic, and other loyalties. B, achieve reasonable regional and gender balance in recruitment and appointment to public offices. C, provide adequate facilities for and encourage free mobility of people, goods, and services throughout Ghana.
All right, so please, good. Please jump to Article 30. No, go to Clause. Go to Clause 7, 8, and 9.
9. Clause 7. As far as practicable, a government shall continue and execute projects and programs commenced by the previous governments. Clause 8. The state shall take steps to eradicate corrupt practices and abuse of power. And Clause 9. The state shall promote among the people of Ghana the culture of political tolerance.
Good. Go to Article 36, Clause 1.
Article 36, Clause 1, economic objectives. Article 36, economic objectives. Clause 1, the state shall take all necessary action to ensure that the national economy is managed in such a manner as to maximize the rate of economic development and to secure the maximum welfare, freedom, and happiness of every person in Ghana, and to provide adequate means of livelihood and suitable employment and public assistance to the needy.
Good. Please go jump to Article 38, Clause 1.
Article 38, Educational Objectives, Clause 1. The state shall provide educational facilities at all levels and in all the regions of Ghana, and shall, to the greatest extent feasible, make those facilities available to all citizens.
Good. Please jump to Article 39.
Article 39, Cultural Objectives, Clause 1. Subject to Clause 2 of this article, the state shall take steps to encourage the integration of appropriate customary values into the fabric of national life through formal and informal education, and the conscious introduction of cultural dimensions to relevant aspects of national planning. Clause 2. The state shall ensure that appropriate customary and cultural values are adapted and developed as an integral part of the growing needs of the society as a whole, and in particular, that traditional practices which are injurious to the health and well-being of the person are abolished. Clause 3. The state shall foster the development of Ghanaian languages and pride in Ghanaian culture. Clause 4. The state shall endeavor to preserve and protect places of historical interest and artifacts.
Right, thank you very much. Yeah, so I just decided to let us walk ourselves through aspect of the directive principles of state policy that's enshrined in Chapter 6 of our 1992 Constitution to reinforce the point which Dworkin is making about the role of principles and policies in the interpretive practice of the law. And from the directive principles of state policy, it's consistent with what we are being told, that these standards are designed to reach a desired outcome and influence interpretation and application of law towards achieving broader social improvement. So you notice that our society, there's a certain destination we want to get to, have a certain vision as reflected in this directive principle of state policy, the preamble of the Constitution, and so on. So all these are supposed to form part of the reservoir of values embedded in the judge's subconscious, so that when he or she is doing the role of adjudication, they will be brought to bear on how the law is actually applied or interpreted. So standards are important in Dworkin's work because standards, as we have seen, bring moral and ethical dimension to legal interpretation. And in the previous class, when we were discussing a case, we saw how one of our friends said that Carson's emphasis on just formal validity actually is unrealistic. But so Dworkin is saying that yes, principles would ensure that some moral and ethical dimension is brought to bear on the task of a legal interpretation. And it will also enable us to go beyond rigid rules. And then the law becomes a flexible instrument capable of adapting to changing societal values and circumstances. And if you remember the famous words of SOA, JSC into Forbes, the Attorney General, that the Constitution of ours is not an ordinary instrument admitting of doctrinal interpretation. It is a living organism. It mirrors the history and aspirations of what? Of the people. And it will say that it calls for a flexible interpretation to take account of the changing nature of society, changing nature of things. And that is what Dworkin is also telling us. And again, when principles and policies are applied in the way that Dworkin is telling us, in that case, legal interpretation will be seen as being inherently connected to values and beliefs of the community itself. So there's there's a proper marriage, there's a proper fit between the values of the community and also the laws which are supposed to be applied in that community. And so law will be relevant and responsive to societal needs and aspirations. We'll give you an example. In 1992, when we adopted the Constitution and came forth in 1993, there are so many things we have in the world today which were not there, but the Constitution should be interpreted in a creative way, which would ensure that the rare vision of the framers of our Constitution for our society, for a better society, will still be achieved by adapting the Constitution to the changing situations that we have. Of course, application of principles and policies also require that judges will need to balance competing interests and considerations. In the society, we have competing interests and consideration, and this competing interest is not just about legal technicalities, but more importantly, moral reasoning and ethical judgment. So when we, for example, talk about justice and fairness, yes, we have a court of justice. We are supposed to do justice and fairness. What is justice? What is fairness? How do we determine the justice of a particular case? So these are matters which will need to be worked out by those who play the role of adjudication. And certainly, there will be conflicting interests, competing values here and there. Let me give you a typical example. So right now, what is happening in our parliament, for example, and the Supreme Court is interesting. We have one school of thought which says that, yes, leave parliament to do everything they need to do over there, including their own understanding of the Constitution and how it applies to their work there. Leave them to do that. The court should not come in. Another school of thought says that no, if you look at the Constitution itself, and if you look at the mandate, the jurisdiction, which have been given the court, and especially the Supreme Court, they are the proper entity or people to tell us exactly what the Constitution means, especially where there is an interpretive issue, where there is ambiguity. So that is it. Now, looking at law as interpretive practice, has it got any implication for legal practice? Judges and lawyers, what does that mean for them? So, one, if you look at law as an interpretive practice, as Dworkin is telling us, then you immediately have to advert your mind to judicial discretion. That judicial discretion is very important. You cannot take it away. And Dworkin, in his work, will grant significant discretion to judges, especially when they are interpreting the law in a way that is coherent with both legal precedents and the underlying moral principles of the legal system. So I told you that when a judge is confronted with a case, if you read Dworkin's work, you talk about a hard case. And by this, it means a case which does not have any precedents which the judge can actually fall on. So it's more or less like a novel case. The judge is still expected to decide, falling upon his understanding of the underlying values of the legal system. And judicial discretion is given because it is expected that there is some judicial wisdom and interpretive skill in legal adjudication. In any case, if you don't make that concession, then you cannot trust anybody to play the role of adjudication, as it were. Or if you want to also come to even like arbitration, like ADR. Another implication is that if you look at law as an interpretive practice, then you have to acknowledge the dynamic and evolving nature of legal system. The legal system is not static, it's dynamic, it's evolving. So that is the one implication of looking at law as interpretive practice. So that will mean interpretation itself will have to be dynamic. So as societal value shifts, so too does the interpretation of law. And this allows the legal system to adapt and respond to new challenges and understanding of justice. So maybe, and that is why if you look at our constitution, for example, when it comes to judicial precedents, okay, or the principle of the stare decisis, if you take the Supreme Court, for example, I want somebody to read Article 129, clause 2 and 3. Somebody should read that. Article 129, clause 2 and 3. Elizabeth, okay. I think Elizabeth and James are the generous members of the class. I'll see them.
Okay, so Article 129, clause 1.
Yes.
Says the Supreme Court shall be the final court of appeal and shall have such appellate and other jurisdiction as may be conferred on it by this Constitution or by any other law. Clause 2. The Supreme Court shall not be bound to follow the decisions of any other court.
Clause 3.
Clause 3. The Supreme Court may, while treating its own previous decision as normally binding, depart from a previous decision when it appears to its right to do so. And all other courts shall be bound to follow the decisions of the Supreme Court on questions of law.
Good. So, Dworkin is telling us that because society is dynamic, legal interpretation should also be dynamic to actually reflect the changing or shifting values in society. So Article 129 of our Constitution is saying that, yes, the Supreme Court, clause 2, the Supreme Court is not bound to follow any court, and that is why we say that the Supreme Court is what? It's a policy court, and people should understand that. if Supreme Court has significant flexibility. It's a policy court. And two, the Supreme Court is required to follow its own precedents because we're a common law country, and judicial precedents, stare decisis, requires that you ensure fidelity to pass judicial decision insofar as the material facts are similar to new ones before you. So that one, there's some consistency. And that also applies to Supreme Court with respect to its own decision. It's supposed to follow them. However, being the apex court and being policy court, the Constitution has given the Supreme Court that latitude, that space to say that, yes, previously, in this case and that case, this is what we held. We do not think that that decision is still a good decision for our legal system or for our society due to X, Y, Z. And for that matter, we are departing from it, and we departed from it. And we say that this should be the position now. So that is what Article 129, Clause 2 and 3 is telling us. And it's also another testament to what Dworkin is telling us regarding the dynamic interpretation of law. Finally, Dworkin's interpretivism, or seeing law as an interpretive practice, blurs the traditional boundaries between law and morality. And it suggests that legal interpretation is an inherently moral endeavor. And that is the difficulty we have in classifying Dworkin. Now, if we look at what, yes, you've rejected natural law, you are criticizing legal positivism for looking at law as a system of rules, but then your interpretive approach or your law as interpretive practice essentially seeks to also integrate law and morality in some other ways. So this unity challenges the separability thesis, which we have in legal positivism. That's the law on one hand and morality on another hand. But Dworkin himself is entangled in this problem again, because if we look at how the interpretive process is supposed to go, there is no way that you can say that morality does not play a role. Yeah, so let's explore a bit more about the role of policy and principle. We have already looked at the directive principles of state policy. So I would like you to spend time and read that. And as Dworkin will tell us that the policies aim at societal goals or improvements. Is it true of our directive principles of state policy? Dworkin will say that they articulate objectives that the law seeks to achieve to enhance welfare of the community. Can we see that from what we read in the directive principles of state policy? I think to a large extent we can, isn't it? And that the policies are future-oriented, and they focus on outcomes that lawmakers believe will benefit society, such as public health, safety, economic prosperity, and social justice. So if you look at even Chapter 5, and not only that, if you look at so many areas in our Constitution, you notice that attainment of public health, public safety, economic prosperity, and social justice are some of the legitimate grounds in which certain actions may be legitimized or not within the constitutional framework. So, how do policies apply in legal interpretation? And when judges consider policies, they assess the law's impact on societal goals. And this will involve an evaluation of how legal decisions will further these objectives, making policy considerations an integral part of legal reasoning in cases where legislative intent and the broader implications of a decision are at play. So there are so many areas of our law in which we will notice that the implication of what the law maker is seeking to achieve by the manifest legislative intent on society should not be ignored in trying to interpret and apply the law. So maybe let's look at some specific instantiations or examples of policy in practice. We take legal regulations and statutes which embody policies such as environmental law. Environmental law in Ghana have our Environmental Protection Authority Act. Environmental laws aim at reducing pollution, or public health laws. You look at the Ghana, how the Public Health Act of 2012. It seeks to curb drug dependence, and traffic laws, which is focused on the road safety. Now, if you look at all these laws, they are grounded in what? In policy objectives. Certain societal goals which we want to achieve, they have been crafted into those laws. So each of these areas we have mentioned involve interpreting statutes and regulation in the light of the broader societal goals they aim to achieve. So if you need to interpret the law, you must have these goals in mind. And later on, when you are learning, statutory interpretation and constitutional interpretation of these statutes in the law school, you learn what we call the purposive interpretation, and purposive approach to interpretation. And if we read, especially this former Chief Justice of the Israeli Supreme Court, Aaron Barak, if you read Aaron Barak's work, purposive interpretation, you will notice that he has drawn deeply from some of the ideas of Ronald Dworkin. It's a very lovely book you will love to read. If not even now, you can read it when you are doing interpretation later on. And that is why I told you earlier on that if you take jurisprudence serious, you must have a very good grasp of interpretation. Yeah, so let's say a few more words about a principle, having considered the policies. Principles in Dworkin thinking are moral standards that have dimension of weight or importance in legal interpretation. So unlike policies, principles are not about achieving a specific outcome, but about adhering to moral and ethical standards, such as fairness, justice, equality, respect for individual rights. So it's different from the policies, as we saw, like maybe the environmental law, we want to achieve, just like, for example, the legislation. Remember the Aishawan case, the Chinese lady, and how people were angry with the relatively short term of imprisonment which they had been given. But that was the law, that was how the law had provided. So now that society is worried that the environment is being destroyed by mining activities. So if laws are made and they're being interpreted, then the adjudicators should know that certain societal goals are being intended to be achieved. How to safeguard our environment from destruction. So that those are policies. But for principles, they provide the moral compass for the law. And that is why if we look at Article Chapter 5 of the Constitution, Article 12. Somebody should read Article 12, Clause 1 and Clause 2 for us. Yes, please. Chapter 5 of the Constitution. Yes, James.
Article 12, Clause 1.
Yes.
Protection of fundamental human rights and freedoms. Clause 1. The fundamental human rights and freedoms enshrined in this chapter shall be respected and upheld by the executive, legislature, and judiciary, and all other organs of government and its agencies, and where applicable to them, by all natural and legal persons in Ghana, and shall be enforceable by the courts as provided for in this Constitution.
Clause 2.
Clause 2. Every person in Ghana, whatever his race, place of origin, political opinion, color, religion, creed, or gender, shall be entitled to the fundamental human rights and freedoms of the individual contained in this chapter, but subject to respect for the rights and freedoms of others and for the public interest.
Good. So, these fundamental human rights and freedoms are examples of what Dworkin is calling like the principles, and it provides the moral compass for the law. So somebody who complained that I'm a victim of discrimination and my right, safeguarded by Article 17 is not being respected. So if you read Article 17, the anti-discrimination clause, it's not about any particular policy which we want to achieve, but just to ensure what fairness. Yeah, so principles have a guidance role in the sense that judges are guided when they're making decisions to reflect core moral values. Moral values. There's a case which I will share with you for you to read. The Ray conjoined twins case, a case which was decided England, I think by the English Court of Appeal, and some twins who were conjoined at the pelvic, and the diagnosis was that they needed to be separated, but the prognosis was that when the separation surgery was done, one of them was going to die, and only the other twin will remain. So that was the conundrum. That was a rare dilemma. You could also decide not to do anything. Don't do the surgery. Just let the people be. Now, if you don't do the surgery to over time, the two will die. So do you want to live, you want to lose the twins, or you want to take an action so that one of them will at least survive? Now, the hospital did not want to do the procedure, because if they did, knowing that one of them would die necessarily, they were afraid they could be charged with manslaughter or something like that under the law. So they wanted the court to come in, for the court to make a determination as whether the procedure should go ahead and they will not be violating the law. And it's a very interesting decision, and it's illustrates what Dworkin is saying, that principles guide judges in making decisions that reflect core moral values. And principles demand a balancing act, where legal practitioners must weigh the principles at stake in a particular case, and will certainly ensure that the law upholds fundamental ethical standards, even when specific rules seem to point in a different direction. And just like the fundamental human rights that we mentioned. So what are examples of principle in action? Just as we saw example of policies in action. Principles are evident in legal doctrines such as presumption of innocence in criminal law. So if we look at Article 19 of the Constitution, everyone who is charged with criminal offense is presumed to be what? Innocent, until his guilt is proven beyond reasonable doubt. So the principle of fairness in contract law. Do you have principle of fairness in contract law? Do you have principle of fairness in contract law? Can anybody explain? Is there anything like principle of fairness in contract law? You've forgotten your contract law? Hello? Ibrahim? Yes, it's not enough. You need to explain. So raise up your hand and then explain. Ibrahim, unmute yourself.
Yes, my lord. I think there's fairness in contract law, by reason that one is being held accountable for one's words or conduct with which one relied on to his or her own detriment, which the law in a way deemed to find it or deemed to see it to be enforceable. And the remedy will be available to the one who relied upon it to his or her own detriment.
Okay. All right. So, yes, Emmanuel, Bobby's hand is also up. Okay. When Bobby, your hand is down. Okay. That's, okay. Yes.
Hello, my lord.
Yes.
The principle of fairness in contracts law on my side revolves around the concept of agreement. That agreement should not be coercive. Implies that contracts should be created and executed without coercion, undue influence, or exploitation of one party by another. That's what the principle of fairness in contract law revolves around. It revolves around the agreements that are made in the contract.
Okay. All right, let's take Charles and then Godfrey. Yes, Charles.
Yeah, my understanding of this concept. Hello. Hello, sir.
Yes, we are here.
Yeah, so when parties agree to perform a specific activity under a contract, and all the terms are being followed, and one party decided not to follow or carry out his terms of the bargain, and want to benefit from the contract, the law will not allow that party to enjoy the benefits. And for that matter, the concept of fairness will come to play, because you haven't performed your part of your bargain and you seek to enjoy the benefit thereof. So the court will definitely, sometimes the remedy may be to compel you to perform your part of the bargain with a specific performance. And if that is done, the concept of fairness will come to play here. Thank you very much.
All right, thank you. Godfrey.
Good morning, my lord, and thanks for the opportunity. I think, yes, there is a principle of fairness in contract, and it revolves around the doctrine of pacta sunt servanda, which states that the parties to a contract have to live up to the terms that they have signed in the contract in such a way that an individual has not been forced, that the will that they have evinced in coming into contract is sacred, is sacrosanct. Therefore, when a party reneges or breaches the terms of the contract, it has a remedy in law so as to put him in a position as if the contract was performed. Thank you, my lord.
Okay, thank you. Francis?
My lord, please, the principle of fairness in contract law is more of like looking into that contracts are negotiated, formed, and performed in a just and equitable manner. In a sense that during the negotiation stages, the parties act in good faith. That is, they do not conceal information, and that they negotiate in good faith, and that they also disclose all material facts, all necessary facts that would influence the terms of the contract, and that in providing an offer, the offer must be clear, and that there must be a corresponding acceptance to that, and that there was also something of value, that's consideration.
You don't follow at the chair, but you seek to benefit from it. Simple.
And then the parties intend to create a legal relation. So it's more of like the fairness. There must be fairness in the negotiation, formation, and the performance of the contract, and it must be done in a just and equitable manner. So that's how I'm seeing about the principle of fairness.
Okay, all right. I think this can be a whole essay, and if I'm to give it to you as an assignment, I'm sure I'll read a lot of interesting things. Just listen to how you are going about it. That's interesting. Okay, so but regardless of how you look at it, there is some fairness in contract, as you have variously illustrated. And even when it comes to frustration, self-induced frustration, where you are responsible for whatever you are setting up as frustration, then it will not count to discharge the contracts. Or when it also comes to, as you rightly said, the formation or the negotiation, especially, just give you an example. Let's say misrepresentation, right? As a general rule, you do not have obligation to make a disclosure. But where you choose to, of course, we have the exception, those a few exceptions where the law imposes obligation on you for you to make a disclosure. But where you, for example, say something which was true, but at the time of making the contract, it was not true, and you knew it was not true, and you kept quiet about it, that also be, unfairness to the other party, assuming the other party continue to accept whatever you propose on basis of that. So you can give so many illustrations. Then where you have prevented the performance of the contract, as you rightly said, you will not be allowed to now complain that the other party is in a breach when you are the very party who made it impossible for him to perform his contractual obligation. Okay, so all these are examples of how principle actually work in action within Dworkin's interpretive process. So how do we, the policy and the principle, how do they interact, and how do we balance them? Is it possible to have a situation where policies and principles are pointing in divergent directions? Well, Dworkin emphasized the delicate balance between policies aimed at societal improvement and principles rooted in moral standards. And in adjudication, judges will face the challenges when policies and principles intersect in complex legal disputes. In such cases, judicial reasoning must navigate these dimensions and ensure that legal decisions promote societal goals without compromising on moral and ethical imperatives. So this is where the work becomes tough and challenging for those in adjudication. How to ensure harmony between principles and policies, especially so when there seems to be a clash. I mean, that notwithstanding, there is some complementarity as far as policy and principles are concerned in the task of adjudication and interpretive process. So while policy and principles serve different functions, they are complementary within Dworkin's theory. So policies direct legal evolution toward societal betterment, while principles ensure that this progression adheres to ethical standards. Yeah, so that is the complementary nature of the relationship. And this is important because the legal system seeks not only to regulate conduct, but also to embody and promote what? Justice. And let me give you an example. That may be, let's say that your society wants to check corruption, okay? So people are being prosecuted for corruption. So the policy is about the corruption, but the rules of fair trial, for example, as under the Constitution, are the principles. So the rules of fair trial, for example, may sometimes clash with the quest for society to quickly and readily stamp out corruption. And that is the type of situation we are talking about. And not only that, when it even comes to this fight against galamsey, yes, people are caught in the very act of doing this galamsey activities. They are arrested. So the policy-wise, yes, we need to get rid of all those programs and all that. But we have principle dimension. These people are still entitled to fairness, entitled to justice, they're entitled to their due process rights under Article 92 of the Constitution. So, how do you weight the principles? What weight do you accord them? Well, Dworkin teaches that principles carry moral weight. That is to say that they represent fundamental ethical values that should guide legal reasoning. And the weight of a principle indicates its relative importance in a given legal context. And it will also reflect the degree to which it upholds core moral and societal values. So how do you determine the weight? How do you determine the weight of how do you determine the weight of a principle? Well, the process of determining the weight of a principle is inherently interpretive, and it requires judges to engage in a form of moral reasoning that considers the broader implications of applying principle over others. So we may have clashes here and then. That is why the weight to accord a particular principle is important. And this will involve an assessment of the principle's underlying values, their relevance to the case at hand, and their compatibility with the overarching aims of justice and fairness within the legal system. It was a very delicate exercise. Now, if the principles are conflicting, what do you do? How do you navigate such conflicts? So, for example, you have the principle of respecting property rights conflicting with the principle of preventing harm to others. So in cases like that, judges are tasked with balancing these principles, determine which should prevail based on their relative moral weight and the specifics of the case. So mind you, there are important principles before us, but there's a clash. Yes, property rights, then do not cause harm to others, avoid causing harm to others. So what criteria should be used in balancing these seemingly conflicting principles? Well, the balancing exercise requires judicial discretion and moral judgment once again. And that is why judicial wisdom is so important. So the example that we mentioned, where an individual's property right may lead to harm to others. For example, pollution from a privately owned factory affecting surrounding community. Then you have like a factory, especially those who in Kumasi, this place, what is the name? Kase, right? Some years ago, I don't know if they're still there, they used to have a lot of these sawmill, these timber processing companies over there. And private companies doing their legitimate business, and yet they're causing so much nuisance, isn't it? Nuisance, pollution to the neighborhood, the surrounding community. So judges must weigh the importance of protecting property rights against the principle of what? Harm prevention. And the decision may hinge on the extent of the harm, the societal value placed on environmental protection, and the implications of restricting property rights for the public good. So we need to do this balancing exercise. The same thing applies to the clash between freedom of speech and then the right to privacy. So when does the public interest served by free expression outweigh an individual's right to privacy? So let's suppose that let's say a public official is having his leisure time or his private time with in his own way, with his friends, however they are doing it or wherever they are. And let's suppose that you are a journalist, a journalist in photography, so you get a very good shots and you publish them prominently for the public, either in the papers or important blogs, which attract significant traffic. Yes, we have the privacy of the public official certainly affected, but is the journalist whose job is just to take good shots of pictures and publish them and just let the public enjoy his work? Can he also claim free speech? So how do we balance these two rights? Or when it comes to like a defamation, especially a libel involving like the public officials, look at the various defenses, qualified privilege, fair comment, and all that. So how do they reflect the balancing of the conflicting principles involved? Yeah, so judges have responsibility, as we have seen, and their training is what will enable them to do this in a way which would reflect what Dworkin is telling us, that they should be able to come up with interpretation which is fair. Now, when it comes to law and morality, Dworkin has his own position, but because of time, we need to stop jurisprudence and do company law. So we draw the curtain down here and get ready for company law. We continue at another time.